homosexual, lesbian, gender-confused community is riding on the back of civil rights, claiming to be an extension of the civil rights movement. This is not a legitimate extension. I repeat, it is not a legitimate extension of the civil rights movement. The Dred Scott decision in 1857 forbade minority people, mainly blacks, from participating as citizens of the United States. That has never happened to anyone involved in the HLGC agenda. The Black Codes of 1865 and 66 restricted the movement of minorities, confining them to low-wage jobs and slave conditions. Such has never happened to those involved in the HLGC agenda. Plessy versus Ferguson in 1896 established a separate and equal doctrine, which marginalized and minimized minorities, both geographically and economically, for 60 years. No such restrictions has ever come on the HLGC agenda. Jim Crow laws prohibited minorities from eating in restaurants and other public places of accommodation based solely on the fact that they were minorities. Those involved in the HLGC agenda have never received such treatment, nor are they in danger of receiving such. Furthermore, the Tuskegee Institute says that 1,277 whites were lynched for the sole reason that they were friends of slaves. Let me pause to remind you what lynching is. It is being beat nearly unconscious, usually kept alive only by the urine of your assailants, demasculinized, your genitals removed, tarred, and hung up and set on fire in most cases. 1,277 whites who were just friends of slaves received such treatment. No friend of anybody involved in the HLGC agenda has ever undergone such horror. Add to that over 3,500 blacks, mostly males, that were treated in the same way. You see that there is no historical match between what is happening in the HLGC agenda and what has happened in civil rights. Therefore, today, I declare a divorce between the civil rights movement and the HLGC agenda.